23.
Yeah, that's where I'll get a 28 from one truck when you're ready.
Go ahead.
From one truck, White Lincoln X-ray 985 should come back up next.
So you had 2000. Patrick Salvik.
10-4. If you can just throw a little note in something like that, I'm going to be leaving a note on the vehicle so they can remove it.
Fuck. Fuck. Rockingham 505. 505 and 50 still is in case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive that's a 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that.
21.
No, 3 in Depot Street. Truck boy entry 5.
7435.
10-4.
10-4.
Can you go 643 again?
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4. I just wanted to know if you wish to be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on the town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
449, 1121, thank you.
10-4.
Code 4. 4.
Rockingham 535.
Yeah, that's Green College.
535.
Not me. You guys know a burn woman who walked into my house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in still. He's about 5 foot, long dark hair, got tie-dye shirt on, and number 21 is over.
We have separation. Inboard now. Upstream.
Hey guys, thanks for being here with me. I very much appreciate it. Actually, going on Court TV at 9, I'll be on with Nick, who I know people have different feelings depending on what side of the case they're on, but he's actually seems like a very decent human being. So he just obviously has some passions about this case that we would disagree about the evidence and things like that. But he does, and the times that I've met him and talked to him, he's a decent human being, guys. So let's always keep that in mind. There are good people on both sides. That's not to underestimate a lot of things that are done on the other side that are not good and are not decent. And the more interesting aspect of this from an intellectual standpoint is the extent that people that in many ways might be decent people that actually do things that are indecent relative to this case. I mean, so many videos we've seen of people booing the O'Keefe family and some of the other destructive things that are done. Is this who they really are? Is this who they normally are? Well, it doesn't seem like that's normally the case, right? But this is the thing with mob mentalities and witch hunts and things like that, is that there's something deep within us that can in that kind of situation get us to do things that we wouldn't otherwise do. And you hope that people have the decency to look in the mirror and have some self-awareness about what they are doing. But that's the whole thing about things like Red Scares and witch hunts and, you know, any other kind of mob mentality thing. Pogroms and stuff like that historically that go on with humans. In the worst case scenarios, lynch mobs and things like that. But people that might not be all bad people, that probably aren't all bad people, end up doing things that really they shouldn't. And a lot of that has gone on in this case. You know, too many things that you don't want to mention it because you don't want to make it worse. But even just messages sent recently to one of the witnesses, shall we say, kids that's in college, trying to cause harassment of her in college. This is disgusting. You know, it's disgusting what goes on in this case. It's not just random people like Steve Coate. It's organized. It's been going on for over a year, long before there were any people protesting on the other side or even asking questions. It's been going on. So we can't just blind ourselves to that. You really can't. Can take these off for now because I don't think I'll need any sound. All right. So we had today, it came out, the big news that the O'Keefe family is suing Karen Read and suing the bars. Now, I want to explain something. I think most people here understand this, but to the people that don't, this is not about money. No more than it was about money with Ron Goldman's parents when they sued OJ. It's about getting justice and accountability in a way that they weren't able to get through the court system. And that's just the way it is. So, because the only way to do that, because it's a civil suit, and in a civil suit, you sue for money. But it's not about money. And so people have said, why would they include the bars in this if it wasn't about money? And the reason is obvious. Okay. In order to get a lawyer or a law firm to take on a case like this pro bono, which means they're not charging you anything. So they're taking it on free, but they're going to get their cut out of whatever you win at the end. The only way they can justify that from their own budget, even if they feel like it's a just cause, is they have to get paid in the end at some level. And so they understand that these bars have insurance, and those insurance companies are likely going to settle. And so that's one way that the law, and I don't speak for the O'Keefe family. I don't have discussions with them. So I'm just speaking common sense here for people that maybe don't fully understand how it works. I was in the bar business for a long time, and you pay liquor liability insurance, and that gives you X amount of coverage. I don't know what the coverage of CJ McCarthy's is, but it's probably at least a couple $100,000. And there are questions as to what is the actual liability of CJ McCarthy's. So in order to be sued for negligence when it comes to overpouring, the way to think of it is this way. You have to show that the establishment knew or should have known that they overserved somebody or they served someone that was intoxicated. Now, from all that we've heard, sorry, one of my lights went down. Let me see if I can get this light back on. From all that let me just hold on one second. Okay. From everything that we've heard, all the testimony, what the hell? Sorry, guys. I don't know why the brain. What the? All right. So all the witnesses testified that Karen showed no signs of intoxication at the waterfall, which was after CJ McCarthy's. Is it JJ McCarthy's? I forget the name of it. I get mixed up with the quarterback that just got drafted. So that's going to work in favor of the bar because there's no, you have to show again that the bartender knew or should have known that Karen was intoxicated. There's no evidence they could have known she was intoxicated because she wasn't showing any signs by all appearances, by testimony. Now, if they understand, so in the bar industry, you get what's called tip certification. There's another one called server's code, and you're supposed to get it every few years. Each individual server, where that could be a waitress or the bartender, whoever's serving the alcohol, and they teach you how many drinks the average person can process based on their body weight. And what they teach you how that affects your blood alcohol level. And in Massachusetts, if you're 0.08, it used to be 0.10, but if you're 0.08, you're intoxicated. And so it's been a while since I've taken the course, but basically somebody my size, it would take roughly 4 drinks in an hour to get me to 0.10. So if I had 4 drinks in an hour, 200 plus pound man, you're going to be a little bit over. In the old days, you would have been like 0.10. And then your body, as far as processing the alcohol, so let's say I get to 0.10, I have 4 drinks, then I can have 1 drink per hour and still be at 0.10. But it changes based on your size and a little bit on gender. So someone who like Karen's size is like 100 pounds. So that doesn't mean that she has half the tolerance. It doesn't work like that, but she definitely will have less the tolerance. I shouldn't say tolerance, but in terms of the impact on her blood alcohol level. So again, I haven't taken the course in a while, but I would guess that somebody like Karen, the server would be trained that if they had 3 drinks in an hour, they would probably a little bit over the legal limit. And then after that, they'd be able to serve them maybe no more than 1 drink an hour after that. So in the testimony, I believe Karen had 7. When I say drinks, I mean 1 shot of 80 proof alcohol. So if you're drinking something weaker than that, so if you're drinking a drink that only has 1 shot in it, but it's a lower proof alcohol, like I think Captain Morgan's is only 70 proof. Something like, say, I don't know, Peachtree Schnapps might be like 48 proof or something like that. So you can drink more. But also if you have a drink that has 2 shots in it, that's basically like 2 drinks. 1 beer would be the equivalent. But again, it varies too. So there's less alcohol in a Bud Light than in a Bud. That's those calories that are taking out of the Bud to make Bud Light are alcohol. So you can drink longer on Bud Light. Tom Fleming has no use for Bud Light. So if you ever encounter him in a bar, please do not send him a Bud Light. Send him a Bushy or a Bud or a Sam Adams or a Guinness, but preferably not a light. So here, the other question would be is how much could the bartender or should the bartender have known that Karen was served? So it sounds like she had 7 drinks in an hour. When I say drinks, I don't remember. It seemed like she was ordering a vodka drink, but then ordering a vodka shot to add to it so that it was stronger. But in total, she had 7. But was it the same bartender that gave it to her? Did they have a plausible, if there's a plausible deniability there where you have 2 bartenders, then if you have 2 bartenders, they can say, well, we're not really sure how many drinks that she had. You know, they're going to be really, really strict about this, where in Massachusetts, unfortunately, it can be kind of strict where they'll say, well, you should have known how many drinks you were serving. It's not practical. It's ridiculous. So if you have 2 bartenders, in theory, the state expects that you're going to tell. If you serve someone a drink, you're going to tell the other bartender so they know, so you both know together how many drinks this person has had. It's crazy. No bar does it like that. No bar could do it that way. But in terms of the legal process, they might say something like that. So I think there's going to be a process here where it will be a little bit of a challenge to prove negligence on the part of the servers or the establishment. However, there'll be an interest on the part of the insurance companies to want to settle, to make this go away, to keep the name out of it and stuff like that. So I would be shocked if they are held liable for something that is more than what their coverage is. So let's say the coverage is a couple $100,000. It'll be something less than that. The insurance company will pay it off. How it'll affect the bar would more be on the rates that they pay for liquor liability insurance. So there may be an effect on that. But I guarantee it's not their first lawsuit. Lawsuits, they're just part of life for every bar. Unfortunately, no matter how diligent you are in trying to monitor people, the law is not reasonable, So, but the only reason, and again, I don't know this from talking to him, but the only reason the O'Keefes would have put the bar on the lawsuit, again, is like I said, is because that's the law firm or the lawyers insisting or handling this pro bono would insist on that. That's the reason that would happen. So it doesn't, my guess is that they feel really bad about including the bars on that, but it's just the way it had to be. But their real goal here has nothing to do with money. It's to get Karen on the stand, because in a civil lawsuit, unlike a criminal trial, she will have to take the stand. Now, this may take years, but she will have to. And there are also the laws of discovery when it comes to civil lawsuits. The lawsuits are different. They're more lax. You'll be able to get a lot more in theory. Again, whatever phone case communications, for instance, but if they've been destroyed, they've been destroyed. Now, people have brought up, and the Turtle crowd, the Free Karen Read crowd, has been excited, like saying that, oh, well, they're, so this is going to open up the Alberts to discovery. That's questionable. It's not impossible. But you can't just go on a fishing expedition. Like, you can't just, so Karen couldn't get discovery on me, for instance, related to this lawsuit, because I was not there. I had nothing to do with it, or you. So you can't go on, or the neighbors across the street or something like that. So is it enough to open them up to discovery, just the fact that John was found on that lawn? Maybe. That's going to depend on the judge. But you're going to have evidence introduced, a lot of it, that says John wasn't. They're going to take this before a judge and say, look, John never came in the house. This is what all of the witnesses said. In addition to that, his GPS shows that he never came in the house. So I personally don't think you're going to get any new discovery. Karen is not going to get any new discovery from the Alberts on this. That can't be said with certainty. I'm not a lawyer. So we can have a lawyer come on and explain this. Nima says she can choose not to testify. Okay, my understanding is that you have to testify, just like O.J. Simpson has to testify in a lawsuit. So again, I'm not a lawyer, so you can tell me if I'm wrong, but you don't have to testify in a criminal trial, but you do have to testify in a lawsuit, in a civil case. So Jennifer says, but she may take the 5th. Yes, that is possible. She would take the 5th. But my guess is that when she testifies, it will be long after the trials are over. Although who knows, they might just go on and on. But the trial is scheduled for January. A lawsuit takes years. So, but yeah, so if she's already been acquitted or the judge has declared there will be no more trials on this, then I don't believe she would have Fifth Amendment rights, but I'm not sure. So again, we'd have to have a lawyer on. I'm not a lawyer, and I'm not going to law school just for this case. So let's go into the actual, keep my eye on the clock too. So I'm going to have to break off about 8:45 because I'm going on Court TV, and I'll be in the early segment, so they usually start contacting me around that time. So I'm going to just stay on till 8:45. So we got a half hour more, and people that are in our Discord, feel free to put questions or comments there, and I will look at them. If you are there, put them under tonight's show. That's the only thing that I'll be looking at. If you are a member here and you want to join our Discord, just email me or communicate me however you can. My email is leitskev@gmail.com, leitskev@gmail.com, and I will send you the invite so you can participate in the Discord. And so some of the people that are here right now talking in chat are also in our Discord, and they've been we've only been doing that for a couple weeks, but it's been a really pleasant community, and they're helping me research the book and things like that. So appreciate it. So let's go into a little bit. I'm not going to read the whole thing on the lawsuit. And for everybody that sent it to me, thank you. And again, I'm not going to go into the whole thing here. So it lists the plaintiffs. They refer to John as JJ. Lists some of the basics of the trial. But some of the interesting aspects, there were some interesting aspects in this. So the charge is that Karen failed to use any care to avoid creating an unreasonable risk of harm to the public. Let's see if I can make this bigger for you guys. I guess I can't. Oh, I can make it. Oh, there we go. All right. Make this a little bit more so you guys can see it. All right, good. That she voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable. So that's because she went 25 miles an hour in reverse after dropping John off at a party where other people were arriving and leaving. So that's reasonable. She persisted in a clearly negligent course of conduct over a noticeable period of time, was impatient with reasonable precautions, was deliberately inattentive to the predictable hazards of her actions, and was deliberately inattentive when there was a risk of great and immediate danger. Now, by the way, these are also very similar to the third prong of second degree. These are also, these are the same things that call it reckless endangerment. If she's guilty of doing these things, she's technically guilty of second degree murder. Now, getting a jury to convict someone for murder on that might be, as a practical consideration, a challenge. But technically, she's guilty of it if she's guilty of those things. So, and again, so second degree murder means the generic description of it is malicious intent. And so when they're talking here, they said that Reed was reckless, that she intended the reckless content that resulted in JJ's injuries or death. So her foot didn't slip on the gas pedal. Her conduct made it highly likely that someone, namely JJ, would suffer serious injury or die. She knew or had reason to know the risk of grave injury or death to JJ, or said risk would have been obvious to a reasonable person. And she intentionally or unreasonably disregarded that risk. JJ's injuries or death resulted from Reed's decision to engage in the conduct referenced above. And those things, they're going to be, she's going to win. Karen is going to lose this case because you don't have to get a unanimous decision in a civil case. And we've already seen that the majority of jurors apparently believe that Karen was guilty of doing this, of manslaughter. So you're going to get the majority of jurors are going to say, yes, Karen is responsible for John's death. So she's going to lose this case. Now, obviously, just like OJ lost. And I don't remember what the settlement for OJ was millions, but the Goldman family never got much of that money. But the jury will have to decide what the settlement is. But I believe it's going to be significant, and it's probably going to be the kind of thing that Karen can never really pay off. So if Karen is expecting to have, if she manages to not be found guilty, if she's expecting to live the life of a movie star, a glamorous star, well, she might be a celebrity in the sense of like OJ, that people still want to take pictures with her and stuff, but it's not going to be easy to keep buying all those new dresses that she buys every time she goes to court. Not going to be easy at all. So this was interesting. This is really interesting. On January 29th at approximately 4:30 a.m., defendant Reed knew that she hit JJ with her SUV. Nevertheless, she woke up JJ's 14-year-old niece, Kaylee, and talked about JJ's death, talked about hitting JJ with her SUV, and otherwise involved Kaylee in her frantic calls about JJ's death. Now, this is very consistent with what I've been saying on this channel, right? That I don't believe that there's evidence that Karen knew she struck John by 1:18 when she left that last voicemail. Now, she may have known. I'm not saying she didn't know. I'm saying there's no evidence. There's not much evidence. The closest thing to evidence was the fact that she called her parents at 1:10, but that's not really evidence of anything conclusive there. I mean, I believe that in those messages, she's threatening John to go home, which is what she was kind of threatening with him during the afternoon. So when she says home, I think the home that she owned was being rented out. So she means going back to her parents' house. So maybe for her to go back there, she wanted to call them at 1:10 and tell them she was maybe coming home. We don't know. That's the whole point, is we don't know why she called her parents at 1:10. And in those 5 messages, there's no indication that she knew that she had been even in an accident, let alone hit John, or no indication that she knew John was hurt. So there's just no evidence for it. So I don't, people get mad at me, but I only follow the evidence. And that's all we can follow. We can speculate. We can speculate as to maybe she knew. And people can say, for instance, people say they find it hard to believe that Karen would strike something that would have made a very loud noise, the glass hitting the car, the elbow breaking the taillight, the dent in the back of the car, there would have been alarms going off. And they can say she would have known she hit something, but we can't know what she knew. She was blackout drunk and in a rage. And so we just can't know. And whether she knew that she hit John or thought she hit a trash can or mailbox, there's no way of knowing. And so it's best to stick with what we know. And what we do know is that her SUV struck her. But there does seem to be evidence that at approximately 4:30 or a little bit after, this is what I've been saying, that at that point, she knew something had changed. So in those messages before that, she was saying that John was cheating on her. Now she seems to have taken a nap. Now we don't know. Karen's phone record was given to the jury, but it was not made public. So we only know what little was talked about by the witnesses. She has said she took a nap for a few hours. So I believe it's very likely she did, unless we find out that she was calling other people. But that probably would have come out in trial, right? And so I have not heard of any other person that was called or texted between 1:18 and 4:38, which is actually when she called John next. So I think all evidence is that she probably did take a nap, woke up, maybe at some point looked again at her vehicle, was putting it together a little bit, and freaked out. That's when she called her parents twice. Second time they took it, that's when she was screaming in the house. She called Katie Camarano, who was working as a nurse on the overnight shift at a hospital. And Karen knew that Mike had been drinking with John earlier. So maybe she, whether she was trying to put it together, we don't know. But she was freaking out. We do know that. She was hysterical. She was screaming. Now, what's new here, because we were not able to see Kaylee's testimony because of her age, that was private. The court reporters were able to see it, I think. Actually, I'm not even sure about that. I'm not sure who was there. I think the court, they must have seen it because there was a couple of reports on it in the news. But so in any case, we don't know for sure what Kaylee said, but we got a little bit more here. She woke up, Karen woke up Kaylee and talked about John's death. So probably similar to what she said to Kerry at 5, Kerry Roberts. John's dead. And I think I remember hearing something that Kaylee had testified to that too, where Karen was in the hallway screaming, I think John's dead, or something like that. So it's worded here, talked about JJ's death. So you can always look at things that are going to be carefully worded in a legal document. So you look at what's not said. So it's at this point, Karen is not saying I killed John. So the document says she talked. So at this point, Karen is speculating, but she's using the word dead, some form of it, in front of the niece. Why? Why would she be thinking that? If John, she drops him off at 12:30, she's accusing him till 1:18 of sleeping around. Why does she suddenly wake up and think John's dead? Why? Like if you dropped off, if someone drops off their boyfriend at an after-hours party, and then they wake up a few hours later, they're going to think that guy's crashing on somebody's couch. Maybe he's even still drinking. It's only 4:30, right? So back in my after-hours days, I would have been still drinking. So, or shacking up with someone like she thought in the voice messages. But that's not what she thought. Somehow something had changed. What had changed? And I think this is what they're seizing on here. And if they can force her on to take the stand, which I believe they can once she's acquitted, if she's acquitted, and I don't expect her to be acquitted, but if she is, or if there's any decision, because there's double jeopardy, you can't be trial again. So as long as you get a decision by the jury, then she's going to have to talk about why did she say that? And, she can just make something up and say, I don't know, I had a premonition, right? But between 5:18 and 5:35, Karen knew that John was seriously injured, buried in the snow, and lying on ground in front of 34 Fairview. So this may be tougher to prove. But it's worth putting in a civil suit because you don't have to prove it to 12 people. You don't need a unanimous jury decision on it. You just need to get a majority. So what is the evidence that she knew? It's limited. So the library video shows her at 5:18 or whatever. She's coming down, I believe it's, I forget the name of the street. Now, if she goes straight, which basically bears to the right, that would take her towards Fairview. But instead, she takes a left onto Washington Street and heads in the direction of the pubs where she had been drinking the night before. Then minutes later, she comes back, and this time she goes off in the direction of Fairview. So the state is saying she went to the waterfall looking for John, didn't see him, and then came back. So this almost suggests that she really still wasn't sure and was trying. Now, someone else had mentioned, and this is a good point, that she may have just been trying to figure out how to get back to Fairview by going to the waterfall first. Because remember, she doesn't know the area. So does she drive to the waterfall and then just try to remember how she drove there the night before? That's very possible. But there are different. The thing is, whenever there's different interpretations of things, it's hard to say with certainty. So even if she did drive back to Fairview, it's hard to know if there's no way to know if she saw John buried in the snow. The only evidence to suggest she might have known that John was in the snow is that when they were driving to Fairview at 6 o'clock with Kerry driving and Jen in the front seat and Karen in the back seat, as they got to the edge of the property, Karen spotted John. And Kerry and Jen both have testified that they couldn't see him buried in the snow. And Kerry's testimony was particularly powerful. Kerry said that even at whatever Karen yelled, she must have said, "Oh my God, there he is!" And she threw her phone down and ran out of the car. I don't remember what she said. I don't even know if anybody knows exactly what she said, but they understood. But Kerry said, "I didn't understand what she was doing because, as far as she could tell, Karen was just running towards a mound of snow," I think was the way she put it. And it was only when she started digging John out that Kerry was like, "Oh my God." And then she got out and helped out. So that's why they believe that Karen had already been there. But again, it's really difficult to prove. It's impossible because Karen could have just seen something a little bit better than they could have, or Karen could have. She had a better indication because she knew that's where she dropped John off. That's not the same thing as knowing that he was buried there. So I think that was the only thing I underlined in this document. Let me just. Yeah, that they immediately started. Yeah, that was it. So that was. Yeah, so that was the main points of interest in that. So. All right, so let's take that document down. I've got about 15 minutes to hang with you guys. So let me see if there's any questions. And I owe somebody a thank you. Lavish said, "Dear T-shirt man, boy, Glare, I still think your super chat dance is the dumbest thing I've ever seen. Sue you later, the McAlberts." I haven't seen that channel in a long time, and I was never a watcher of it. It is annoying, but whatever. I don't know. Is he getting a big following now? I don't even know. He probably is. Anybody that's doing conspiracy stuff in the true crime world is going to get a big following, and definitely free Karen Read. So I was on the phone all day today with various, catching up with some old sources, but also a certain documentary maker was talking to me, and podcaster. Just a whole bunch of calls. I hope my brain is not completely fried. It's already feeling a little bit fried right now. I hope it's not completely fried by the time I go on Court TV, because Nick will kick my ass. Nick is you have to admit, he's a pretty sharp arguer. Ghost Rider, welcome. Good to see you. Francesca has always been a big help to me. Maui Swift, another big help. Jennifer, huge help. These are my team. I appreciate it. So anybody else that wants to join the team, reach out. Yeah, and that's the thing about blackouts. So when you have someone that is a longtime drinker, longtime regular heavy drinker, they will get blackouts. And these blackouts, they can be pretty functional during the blackouts. It's amazing. There was an episode of 2.5 Men. I love that show. And Charlie comes home wasted one night, and he makes his 2 a.m. chili or something, or whatever they call it. And of course, the next day he doesn't remember making the chili, and everybody's like, "Wow, this chili is great. Thank you, Carrie. I appreciate it." And everybody's like, "This chili is great," but that's what it is. Blackout people that are longtime drinkers, which I used to be, and I don't anymore, but I very seldom drink now. But you can be prone to having that blackout where you can be. I was never prone to blackouts, but I don't want to say I never had one. But yeah, people would do this, and yeah, there's even people that would have told me stories about how, after a really bad night of drinking, the first thing they did the next day was go out and look at their car to make sure there was no damage on it. So it's difficult. Kevin, post some info on how it works with her being able to refuse to take the stand. Well, I'm going to have to talk to Mahoney because I'm not a lawyer. So I can't, I give the best to give you my understanding of it, but I'm not a lawyer. So, I mean, so sometimes if we have something specific like that, I can go and actually sometimes Kevin watches the show and the questions that you guys ask me or that I ask here, he'll call me the next day and answer them. So I'll try to call him tomorrow. But, lawyers are very busy people, so I don't generally bother them. So I tend to wait for his answer, for him to call me. But he sometimes, if he's bored, will watch the show and he'll get an answer. But I don't know. To my understanding is that other than the possible Fifth Amendment defense, you have to take the stand in a civil lawsuit. That's my understanding. So if there's any lawyers here, Heather's a lawyer, so please, she can tell me. Heather says, yes, they can plead the Fifth if it will implicate them in a, right. So if it'll implicate them in a criminal manner. So Heather, the question would be this: if the trial has already been decided one way or the other, guilty and she's sentenced to nothing or acquitted, but once there's a decision by the jury, you won't be able to plead the Fifth on anything unless it's related to a different crime, right? Heather, does that make sense? So if they ask her something related to a different crime, but related to these specific charges. All right. So I'm looking and getting an answer from a lawyer who I'm not supposed to mention their name, and I never do. And so let me see if we get a better explanation that I gave you. Let's see. Okay, this is probably similar to everything I said. So just she's adding to it. Good, he or she. In civil cases, the jury needs to decide there is more evidence than not, a preponderance of the evidence, meaning 51%. Right, exactly. So that show a defendant is liable for the allegations made in the case. So that's true. That's better said than I was saying. So they don't have to prove beyond a reasonable doubt. They have to just prove by a preponderance of the evidence. I have jury trial coming up myself in September. It's the third time. Well, I've been on 2 juries. So so my knowledge of the law comes from being on 2 juries and my cousin Vinny. But a lot, from my experience, I have a little bit more knowledge of that just from things that I dealt with from owning a bar and stuff like that. But, the thing about the law is it's really mostly common sense. Things get laws are written the way they are for a reason, and case law is established through precedent, but that's done by a common sense interpretation based on the law and other precedent. So, but I've never seen anything where it's not common sense, but So Heather says, the thing is, though, they are assembling that taint team and we don't know. So yeah, the taint team. So they took Karen's phone in January. Supposedly she wiped it. We don't know what's on it. But they must have been able to get something off it if there's a taint team. So, so there could be other charges, but my thinking is that if you're asked something related to those other charges, then you take the Fifth on that, right? So you can't just use the Fifth to avoid taking the stand. You can just use that while you're on the stand to plead the Fifth if it's right. Isn't that how it works? Am I wrong? There may be more criminal prosecutions coming, and we're talking about conspiracy charges. So I have about 8 minutes left. So if anybody has any questions or comments they really want me to get across. Heather says if she was her lawyer, she would have her take the Fifth. But can you take the Fifth on every single question? Heather, So I don't know. I mean, could she still be charged with DUI, I guess, or something like that? I mean, she's charged with OUI manslaughter, so I think that will be covered by that. Mr. Anderson either is from the Matrix or is a lawyer, so hopefully, or maybe both. He says in civil cases, it's not like criminal. You can be called as a witness against yourself. Did they say an amount that the family is suing for? I don't know. But again, it's not about the money. It's not about the money. And my understanding is that the families involved in all the other ways, the witnesses and people falsely accused, they all support this because everybody's trying to get the truth out except for Karen. And that's what they want. And, would they have sued had she been convicted? I don't know. I couldn't say. But there is a 3-year statute of limitations. So they did have to get this lawsuit out by this coming January, right? So I'm reading chat, looking for questions. I'm also hoping to get that boost of energy that someone might have if they say something really funny. Tom Fleming, come on, you must have something funny going on down there. Rogue, come on, you got a joke going or something. Let's lighten the mood here. Seichner says sometimes the civil case gives the legal case a boost. So that would be really interesting. I would love to have somebody like Mahoney on to talk about cases similar to that in the past where I'd really like to, if anybody has any information on that, thank you very much, Rena. If anybody has any information on that, where a civil case, new information came out that was used to further the criminal case, that would be awesome. Football watch parties. That's a really interesting idea. So we did an NFL draft and there was only like 20 people here, but we could do that. I mean, I'm a huge NFL fan and a crazy huge Patriots fan. I was a Patriots fan all the way back to when I was a kid in the 70s, and all through a lot of those bad years in the 80s and early 90s, I still kept watching. I remember this one girl I was dating, I'd be at her house. This is when I lived in Worcester, and I'd go to her house and I would sit in the living room watching the Patriots that no one in her family had any interest in because she's like, and they liked other sports, but like, those Patriots suck. I don't know how you watch them. And so I'd be sitting there watching the Patriots by myself in her house, and her father would be kind of laughing at me, and they'd be getting killed because back then they were getting killed. Well, kind of like it's been the last couple of years. But I would do something with football. Look out for my bad dad joke. Well, Fran, don't feel free to put it on Twitter. So I'm sorry, on the Discord, so I can see it. Throw it in the Discord because sometimes chat moves too fast and I miss something. Tom Fleming has nothing funny to say. All right, see, that's kind of funny. See, that's why Tom could have been a comedian. Sometimes everything's a little bit funny. Court TV in 20 minutes. Yeah, so I only got a few minutes and then I got to jump off. I'll be getting, in fact, I got to open up that channel right now because they probably will call me earlier tonight. All right. I just love the NFL, or I love being a football fan of a team because they only play once a week. So the regular season is so much more meaningful than it is in the other sports. And I'm a huge Celtics fan. I grew up a huge Red Sox fan. I still kind of, but can't have the same interest. Maybe I'm spoiled from the winning that they did. I don't know, but you know, yes, I'm going on. So I'm going on Court TV at 9:00. I got the list of topics, and it's unfortunately it's like stuff that we've talked about so many times before, but maybe they'll change it now that word came out about the lawsuit. So we'll see. But it's kind of, I feel like I could have this argument with Nick, and it's like just replay something from what we did before. It's not gonna be anything new. But yeah, I'll be on at 9:00. Do I think change of venue and gag order? I mean, it seems like I don't, I'm not a lawyer, but another possibility, like for instance, in the Delphi, Indiana case, they're busing in the jurors from pretty far. It's like a 2-hour drive, which is crazy. So they're going to spend 4 hours on the bus. What are they going to have? Like 2 hours of trial? I don't really understand how they're doing it, but they're busing in jurors from a county that's fairly far away from the county that Delphi is in. I forget the name of that county. So I don't know. Is that an option here? Could you bus in jurors from Springfield? Or maybe a little bit closer, like Worcester. I know there was some speculation about moving the trial to Brewster on the Cape. But the problem is that creates a real inconvenience for the witnesses that would have to drive there, obviously on John's family and having to go there every day, and, Karen's family. So, I am, as soon as I hit 8:44, and sometime in the next several seconds, I will have to bounce out. So last thing I can say is, like I said, anybody that wants to join us in the Discord and help us out, it's a small but fun group, and they are helping me a lot with the book. My goal is just to have the book out, so it's out in December before the trial, in time to maybe have some slight influence on the public perception. But there are other things going on in the documentary and podcast world that I can't talk about, but I do actually believe that the narrative, that there's a chance the tide is starting to slowly turn, but we'll see what happens. All right, guys. So I have to end here and get ready for the other show, even though this is much more fun. So I will see you all soon. Thank you.